Good afternoon, Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I'm also here to talk to you about a particular topic. Thanks for joining me. It's good to be back, and I would love to go ahead and take your questions. Start putting your questions in the comments now so that I can address them as soon as I'm finished talking about the topic that I came to talk about. And that's going to be, what do you need to apply for VAWA? Now, as a recap, or for those who are just joining me or just watching me, I know my friends who have been watching me for a while, you already know what it is. You already have joined me on many lives, so you know what I'm about to say. But for those of you who are new, what is VAWA? So VAWA is, the official name of it is Violence Against the Women's Act. However, I don't really agree with that name. I wish they didn't name it that, because it doesn't, it's misleading. And it also gives off that whole stereotypical vibe that men can't be victims of domestic violence, only women can be victims of domestic violence. And that's not the case. Even though it's named Violence Against Women's Act, it's for everybody. Everybody, no matter your gender. If you've gone through a type of mistreatment that qualifies you for the relief, then you can apply for this, whether you're a man, whether you're a woman. No matter what kind of marriage you're in, you qualify here if you go through the mistreatment. And then the other part of this name, VAWA, that I think is misleading is the violence part. When we hear violence, we think physical violence. And because of that, many people automatically take themselves out of the process, or out of qualifying without even talking to an attorney, because they think, I was never physically hit, I don't qualify for this relief. But the VAWA does not just include people who are victims of physical violence. It also includes those who have been mistreated in other ways. So the official term under VAWA is called extreme cruelty. And if you've been subjected to extreme cruelty, you can qualify for relief here. Extreme cruelty means that they have used verbal abuse, emotional abuse, different tactics to keep you compliant with them, to keep you to get you to do what they want you to do, to control you. If their mistreatment also has that effect, it has a bad, terrible effect, traumatic effect on you, and the goal of that is to, maintain control over you, manipulate you, put you down, then this qualifies you also for VAWA. Which brings me to the next question that I usually get. And it's like, well, what do I need to apply for this? I mean, they only, which only is kind of minimizing it, but you would be surprised how many people know that they're being mistreated, but they go ahead and they minimize the kind of abuse that they go through by saying, well, I only went through verbal abuse. What can I show? Now, even though you went through verbal, emotional abuse or mistreatment, extreme cruelty, it leaves internal scars, and that can be just as ugly as the external scars. That's first of all. And what I usually say in response to, well, what can I show, is your memory. You have your memory. You have the memory of what you went through. And that's enough to put your statement together, a detailed statement together, to be able to express to the officers in a consistent, detailed manner what you went through and the effect it had on you. There are other requirements as well, and I usually guide my clients through these other types of requirements, and that is the you have to show bona fide, your marriage is bona fide. You still have to show that you're a person of good moral character. You do have to show that at some point in your relationship, You and not even if you live together before you are married, that also counts, but you have to show that you did, if this is a spousal relationship, that you did live together with your spouse at some point in your relationship. So I help my clients to navigate these different areas on how to show the evidence. Now, your declaration is one thing. Now, let's talk about the bona fides of the marriage. How do you, because just like the marriage-based process where you have to show that your marriage is real, under VAWA, you do have to provide evidence to show that your marriage is real. Now, under the standard of VAWA is any credible evidence. And the reason why they say any credible evidence, which means any believable evidence, which could include your statement, is because they know that in this type of situation that you were in, you probably don't have a lot of evidence. Some people do, some people don't, because sometimes the whole goal of the spouse or the relative who is mistreating you is to also never leave a paper trail or never empower you in that way by giving you the paper trail or the evidence that you need to show that this is actually happening to you. So, for instance, they may not want to see you empowered by not, they may not put you on the lease, they may not put you on the bank account because they know that empowers you. That gives you the ability to get the financial stability you need to possibly go off on your own. And they will not give you that leeway to do these, to be a partner to them or to have your name on a lease or on a bank account. So to start with, you may not have the traditional evidence necessary to prove a bona fide marriage. And in that case, we look at alternative evidence. So declarations of others, witness statements from others, and other types of credible evidence, such as correspondence between the both of you, maybe text messages, maybe emails, if you exchange emails. Um, and the kinds of evidence that you're going to show is going to depend, of course, on the type of marriage you had, who had knowledge of your marriage, and the way that you lived your lives together as a married couple. So, this is where it's important to get the legal representation necessary to go through your process and to prepare a thorough, solid application to improve your ability to succeed here. All right, so now that I have talked about some of the requirements, what you need to apply for VAWA, and let me just finish it out by saying this. VAWA is well worth it when you're in a situation like this because you're able to empower yourself, gain independence, not depend on someone, a relative or a spouse who is mistreating you, who is possibly even threatening to sabotage your future here in the United States. You get to cut them out of the process and only move forward on without them. No need for them to sign off on documents. No need to live with them. No need to go to the interview with them if necessary. You don't have to stick it out with someone who is doing this to you to get status. You can move forward on your own. And what happens is you go through a two-step process. Now, even though at the beginning we do file for your VAWA and your green card at the same time, and this is because if you're married to a U.S. citizen spouse, you can do that at the same time. If right now you're married to a permanent resident, you can apply for permanent residence at the same time as VAWA because there's no wait list if you're married to a permanent resident. And if you're the son or daughter of a U.S. citizen who is under 21, then the same goes for that. Is there's never a wait list, so you can always apply for adjustment of status. So at the point that you apply for the adjustment of status and the VAWA application, then you are scheduled for a biometrics appointment. 3 to 6 months after that, you get what's called a prima facie determination letter. And the benefit of the prima facie determination letter is that in some states you are able to get started, settled with some benefits. You may be able to get your driver's license. You may be able to get further assistance to settle while you wait for your work permit to come through. About 9 months, 6 months, I'd say, to a year, you'll get your work permit. And then once you get your work permit, it gives you the ability to get your social security number. This allows you to work anywhere you want to work, live anywhere you want to live with this work permit and the social security number. And you'll be able to have this for 2 years. At the 2 years, it's renewable until you get your green card. Now, step one of this process is you get approved for VAWA. Once you get approved for VAWA, they issue another work permit for you to be able to continue on this work permit under VAWA status. And then after this, you get approved for VAWA, it automatically moves on to the green card stage. And about 6 months after, 6 months to a year after approval of the VAWA, you will then become a permanent resident. Another benefit of this is that you don't have to wait the usual. If you are married to a citizen, when you applied for VAWA, or it is based on mistreatment by a US citizen, you get to apply for citizenship 3 years after being a permanent resident. That means you can apply for citizenship within a shorter period of time. And by the way, when you do get your green card, you get the 10-year green card. You don't have to get any 2-year green card and go back and apply to get the conditions removed. So even though it does it does take about 2.5 years for the process to be completed, you are able to get these benefits along the way. So it helps you to stabilize yourself, helps you to move away from the toxic situation that you may be in. And you'll hear me say this a lot. Sometimes you need to step away and apply for VAWA to protect your own interests. Because if this person or this spouse is threatening to sabotage your process by withdrawing the application or by calling and reporting, telling a lie on you and reporting that you're committing fraud or that they're going to get you deported, believe it. Believe it. Right? The VAWA is not going to protect you if you don't apply for it. You can't think about it as an option that you can pursue later on, because later on may make it too late or make your process very complicated. So if you see the red flags, you see a spouse that is mistreating you, that you see they're probably not going to make the interview, because if they say they're not going to make the interview, believe it. And I've seen it. And this is where we have to do emergency VAWA petitions when individuals come and say, my spouse didn't show up, or worse, the spouse shows up and ends up signing documents to immigration saying, yes, they only were helping out their spouse, and the marriage isn't real. Because they will do that. They will do it. So make sure that you take those into consideration and look out for your own interest and your future here in the US, because that if you don't make that decision, that spouse or relative is eventually going to make that decision for you, and it's not going to necessarily end well for you. And I don't want to scare you, but I think it's a reality that I see very often. I see that as the end result, and this is where I have to jump in and do emergency VAWA applications because of this. And it's very stressful for my clients because now they're under threat. Their future here in the United States is under threat because a spouse, a citizen, or usually a spouse, will be that cruel, where they mean that they're not going to see you get that permanent residence, and they will do everything to make sure you don't get it. So protect yourself, be proactive. and evaluate your options to apply for this so that you're applying on your own and you're gaining independence and walking away from someone who is mistreating you. Now, I'm going to go ahead and answer some questions. So go ahead and put your questions in the comments now, and I'll answer your questions. I'm just setting up here. All right, so let's see. I'm excited to answer some of your questions because it's been a while and I want to make sure I get to your questions. All right, so I see some on YouTube and I see on Instagram. So hang tight while I scroll through and just answer your questions. So please tell about the U visa. So the U visa is for victims of crime, and you get to apply for this if you have been the victim of a crime that has resulted in your mental or physical abuse. Now, some examples of crimes that are qualifying crimes where you can get the U visa is if you've been assaulted, if you've been stalked, if you have been the victim of stalking, robbery, kidnapping is one of them, domestic violence. So if you have been the victim of this type of crime and the crime was reported to law enforcement, then what we do is we go to law enforcement. We either make the report if it hasn't been reported, or we go ahead and we go to the law enforcement agency that responded and we ask them to provide us a U certification. Now, they will look to see that you reported a crime. It doesn't necessarily mean that it ended in an arrest or a prosecution or a conviction for them to sign off on this U certification. And the U certification can be signed off on not just by police, but it can be signed off on by prosecutors. It can be signed off by different law enforcement agencies along the way who did the investigation along the way. But once it is signed, then it means that we can then submit the U certification application showing proof that you were the victim of the crime, that it resulted in your physical or mental abuse, and that you do have evidence that you cooperated with law enforcement on it, and the U certification is for this. Now, the U certification is required to get to the U visa. There are some downsides of the U visa. The U visa is it's 10 years, 7 to 10 years right now. There is a wait list right now. So while you're waiting, to get the U visa, you can get what's called a bona fide determination letter. That comes at around the 2 year mark, 1.5 to 2 year mark after you've applied for UCERT, that they'll look, see, have you applied, have you passed your background check? Have you submitted a valid application that looks like you qualify? If so, then you can get on the wait list, and this will give you a deferred action that gets you the work permit that's renewable until you get approved. So you're able to still stay here in the US and get your U visa eventually, but get your work permit on the deferred action while you wait for the final approval. And the reason it's taking so long is because there is a cap. Every year there's a certain amount that has to be approved. And once that amount the cap has been reached, you go to the next year. Everybody else goes to the next year. And it's right now is 7 to 10 years long, unfortunately. Okay, so I just got approved for my T visa, and my mother back home is severely getting ill. Can I leave to take care of my mother or bring her over under my visa? So it's going to depend on your age. So if you are under 21, you are able to bring your parents here as derivatives of the T status. However, the part of the T status or T visa is to show T status is to show that you will experience extreme hardship if you go back to your country. It's sort of like asylum, right? Where if you're applying for asylum here, how is it that you're going to go back to the very country that you're saying you can't go back to? And so, because of that, the T status it can create some problems for your visa if now you're returning to a country that you said you can't, that you'll experience extreme hardship. Now, getting the T status, once you have T status here in the US and you leave the country, it means your status is over. Your status is terminated and you have to go back to the embassy to then get re-evaluated again for the T visa. Because remember, when you're here in the US and you get the status here, it's called a T status. When you go to outside of the US and you want to come back in, it's called a T visa. Well, guess what? The T status is evaluated by the USCIS office, but then if you go to your home country, it's the embassy that's going to look at it. And sometimes they start from scratch. They look at everything all over again to determine whether they're going to give you that visa. So if you are under 21, then your mom would be able to come on the T on a different on a T status as well, T visa as well. If you're over 21, then the way that a parent can still come if you're over 21, a relative can come, is if they themselves have also faced a threat of the trafficker involved. Because remember, the T visa is for victims of labor or sex trafficking. So, it's talk to your attorney about this. This is where it's so important to make sure you are represented so your attorney can advise you about this. Always defer to your attorney if you have your attorney, if you're already represented. But this is a conversation you need to have with that attorney. But I always say it's not worth the risk of leaving because you may not be able to get back. After getting married to my spouse, how soon can I apply for the green card? So there's no law, no regulations that say that you have to wait to apply for the green card. On the other hand, is it advisable? That's going to be the question here. I use this example. Say you met your spouse, you eloped after meeting your spouse on a Friday. You were in Vegas, you had a great time, you met the love of your life. By Saturday, you guys were married in Vegas. Is it, should you be applying for adjustment of status by the Monday? No. I would say give it some time because you just eloped, just got married. I doubt you have everything that you would need to apply. You don't have paperwork showing you have a bona fide marriage, like a joint bank account, a joint lease. Probably haven't even figured out how you're both going to live together yet. You're going to have to give it at least a month to get all of those things settled before you apply, right? So in reality, that's what you have to look at is at the point where you are at, do you stand the best chance of getting approved? Another issue here is possibly, are you here in the US? And if you're here in the US on a visa, is it advisable to say you flew in on a Thursday, you got married on a Friday? Is it advisable to file it on the Monday? There is what's called a 90-day rule, where if you submit your documentation right after entering the country, they can then read this as misrepresentation or fraud. Because when you enter the country with your visa, you represented to the officer just by virtue of having a B visa, a visitor's visa, that you're coming here to visit, but yet because you filed your paperwork so soon after you entered, it's showing your intention was something else. So you may have to challenge possible accusations of misrepresentation. So these are issues that you definitely have to keep in mind, even though there's no rule that says you can't file the papers right after marriage. And I filed by the way, I have filed these papers on behalf of my clients right after they got married. But here's where it's different than just eloping on Friday and then filing the papers on Monday. Is that my clients, they had a long-standing relationship before. They had a 3-year relationship before they got married. They were living together before they got married. Then they got married, and we filed the week after they got married because they had everything to show that they have had a long-standing relationship and they're now getting married, just sealing the deal and moving on. So, in some cases you can, and in other cases it may not be advisable. But this is where it's really depends on your particular circumstances. So we have been married for 4 years, and he refused to file for me, but he's asking for a divorce now. So get in touch. Let's talk. Now, even if you are divorced, you can still apply for this up to 2 years after the divorce is finalized. But get in touch. Let's talk about your circumstances. Because refusing to file for your papers is certainly, after 4 years of marriage, is certainly a sign here that there's something wrong. And this is where I have to find out what that something is that was wrong, because I know that any spouse that cares about you is not going to let you sit here without your papers for 4 years. They are mistreating you. It's a sure sign to me that they're mistreating you, but I have to understand what's going on, what's the nature of the mistreatment, to be able to advise you further on what the best step is. Now, even if you haven't filed any papers, you can apply for VAWA. You don't have to have papers pending to file for VAWA. All right. I filed for VAWA in 2022, waiting a year now for prima facie. Does it take that long? So, waiting a year for prima facie is long. And in cases where it does take a while, we reach out to the VAWA unit just to make sure that it wasn't lost in the mail or there wasn't some issue with the mail. Because with the prima facie, they don't necessarily put it in the status updates, so you'll never know unless you check in. The average time I'm seeing for prima facies are about 3 to 6 months after we've gotten confirmation that their application has been filed. So this is where you should really check on that. I-360 got approved. Do you think USCIS will focus on previous divorce decree if filing for green card, as a divorce decree is part of the requirement? So you definitely have to show the divorce decree during the adjustment of status process. Now, getting divorced is not going to, now getting remarried before your I-360 got approved would definitely affect you, but getting divorced is not going to affect your process. Just make sure you have that divorce decree that you can present to the officers. Now, usually when you get to the adjustment of status part of it, they don't question you about the nature of the mistreatment, but they want to make sure that all the documents that you do provide shows valid, that you went through a valid marriage, valid divorce, and so forth. So it's more for verification purposes than necessarily it doesn't create a complication for you. But keep in mind, always defer to your attorney. If you're already represented by your attorney knows your case best, and they know what the particular facts are involved in your case to be able to prepare you for a possible interview or any further questions that may come up. Because remember that I am not your attorney. I am here to give you general information. And so this is where representation matters, because I am there's no way I can give you the accurate legal advice through this live, but I can give you general information. And based on generally, they're not going to use a divorce decree against you. um, unless that divorce decree is indicating that say you got married before your I-360 and then you got divorced from that person after the I-360 was approved, then that's indicating that you didn't even qualify for VAWA to begin with because you got remarried. So if the divorce decree is revealing new facts that disqualify you, then certainly that's going to be an issue. But if you're divorcing the spouse that mistreated you, it's not going to be a problem. Hi there. Good morning in California. I'm still waiting on the second prima facie letter from immigration. Is it normal for it to take some time to receive it? The first one I received has been expired for 2 months. Yeah, unfortunately, it does take some time for them to automatically reissue the additional prima facie notices. If I miss my biometrics, is that a bad thing? Can I be denied? Missing the biometrics does put you at risk. Make sure you contact immigration to get it rescheduled again ASAP, or have the attorney make sure they do it. I filed for VAWA June 8th, no receipt yet. Yep. These are taking sometimes months to get the receipt notices. They're backed up, so it's not anything new to wait 2 months to get that receipt notice. I filed VAWA. Let me see. Good morning, Terrian. It's so nice to see you. Can I travel outside of the country with a VAWA visa? Now, with the VAWA visa, I don't know about the visa. If you're talking about you currently have VAWA, you are approved for VAWA. It's not a visa, it's a type of status. Now, if you get that here in the US, what you'll have to do is get a travel document, get advance parole to be able to travel. So never leave the country without applying for your travel document first. Hi there, Lindy. So nice to see you. It's prima facie renewed every year. So it's renewed. So it goes for 1 year. And then if you are continuously, they're going to renew it, it's probably every 6 months that they're going to send you a renewal. Hello, I got 2-year green card a month ago. My spouse mistreated me. So I want to apply for the I-751 based on abuse. So when I get divorced, will USCIS cancel my 2-year green card? No, absolutely not. As long as you do apply for that waiver on the I-751 based on the divorce as well as a mistreatment. And this is exactly what we do for our clients. So this is where you need to call and schedule an appointment, and let's talk more about it. But you have options. You just have to make sure you take action and you apply on time to be able to take advantage of that waiver. You're welcome, June. Now, can I apply for the I-751 based on abuse after getting my 2-year green card a month ago? So the general rule is when you're applying based on a waiver, you're applying for the I-751 removal of conditions on your 2-year green card to get the 10-year green card. The general rule is you have to apply with your spouse when it's within 90 days before the card expires. However, if you're applying based on a waiver, you can apply at any time before, during that 90-day period, or after. Although I don't recommend any time after, but that waiver, you can submit the waiver anytime after. If your circumstances change, your spouse is now mistreating you, and you've submitted the application to remove the conditions, but now you no longer want that spouse to apply with you, you can apply for the waiver and change it only to your process. But then you have to think about, like, from a strategic point of view, is it best to apply for the removal of conditions now, or to wait for your card to approach the expiration date before applying for the waiver? And this is where the consultation is going to be very important to determine what's best for you. So I meant the previous decree before married to the abuser. Will it affect my case if filing for the green card, but I-360 approved? Not necessarily, but it sounds like you're going into very complex territory, and it's going to depend on what were the circumstances involving that previous spouse before your abuser. This, I don't want to say it won't affect your case because I don't know what's the point of concern here. Usually, if you're asking this question, it's because you're concerned about something in the past, and this is where it's important to have an attorney or talk to your attorney. How long does it take for a green card to be issued after you file for a marriage document for more than a year plus? So I've seen anywhere from 5 months to a little over a year, but I don't know if what are you applying for adjustment of status, or did your spouse only apply the petition? With the petition, you're looking at about a year to get the petition approved, the I-130 petition. I have the green card for 2 years, and my husband has just told me that he no longer wants to live with me. He wants a divorce. What should you do? Now, if you have the 2-year green card, and now your spouse wants to divorce you, there is what's called the I-751 waiver that you can get based on divorce, or if there was mistreatment based on the mistreatment. Go ahead, give us a call. We can definitely help you with this. If your daughter is in the military and want to file for her mother, she needs to be 21. Yeah, but no, there are certain situations where your daughter can also apply for you to get a form of deferred action or parole in place, but it's going to depend on how did you enter the country, what are the circumstances surrounding your entry into the US. So my friend just asked, what is the reason why people get prima facie granted? So the prima facie is a type of determination that the immigration service makes when they believe, based on a preliminary review, that you qualify for VAWA, but they have to then pass it on to get a more detailed review. And in the meantime, they want to make sure that you can use that prima facie determination letter to possibly get a driver's license or to get certain benefits to help you settle in while they make that final decision. So it does mean that your case is going in the right direction. They just need to make a final decision on it. So I already have my VAWA traveling documents approved, my parole. So do I need my prima facie renewed every 6 months? So it's yes, you want to see that prima facie renewed every 6 months because you could have it as backup in case you do need the prima facie in your state for certain benefits. And it also is reassuring because it means that they still believe that your case qualifies. It's just that they still have to do a more detailed review. So it's a reassuring thing, and it's not something that you ask them not to issue. And you don't have to wait for your prima facie to be issued, though, to travel on that travel document. How long will it take to get a citizenship interview in Indianapolis after applying? So I wouldn't know that the processing times. I'd have to check the processing times for that particular office. But I have been seeing my applications go through anywhere from 2 to 6 months. How long does it take to get a green card after VAWA approval? So about 6 months to a year after the approval. How can I get in contact with you? So go to the link in the profile on Instagram. You can also go to the description of the video on YouTube, Facebook, and Twitch. You'll see the link there. The link takes you to Linktree, where there's a link to the website. There's a link to schedule your own appointment. So you can choose any one of those. On the website link, you'll see the phone number, contact form, online chat. All three of those lead to scheduling coordinators who will be more than happy to assist you. I sent the fingerprint for my VAWA case since 1 year ago. I still don't have notice from them, so it's backed up, and that's not strange at all. So I've applied. Hi there. I applied for VAWA and I-485 together and got my VAWA approved. Do you know how much time it takes till my I-485 will get approved? Now, keep in mind that the timeline is an estimate based on my experience as an attorney. However, it does not mean that I'm giving you the accurate timeline from case. The timelines I'm seeing after it's approved is 6 months to a year after your VAWA has been approved. If my child is waiting on interview for consular, can I switch him to adjustment of status? It's possible, yes, but you have to make sure that your child qualifies for that. If you are a US citizen or the step parent is a citizen and your child is under 21 and they entered with a visa, then yes, that is possible. Now, how can I contact USCIS about my prima facie? Now, it's tricky when you're dealing with VAWA. They will not talk to you over the phone. And if you don't have an attorney who can contact them through the email, we are assigned an attorney email that where we talk to them directly. You have to do it by mail, by snail mail, unfortunately. I overstayed my visa, but I was married to a U.S. citizen for 2 years. For 2 years, and I think if you've divorced your citizen and that spouse mistreated you, you could still qualify for the VAWA, but you have to make sure you apply before 2 years after your divorce. If 2 years pass after your divorce, then you no longer qualify for this. So, which month does VAWA are they working on? So they don't usually disclose the month they're working on, but they do have case processing times on the USCIS, and their average processing time right now, I believe, is 3 years. So it is taking a while, and this is a range of time. So on the farthest end is 3 years. My friend received a work permit and they wrote work only on it. Why is that? No, with the work only, well, it is for work, and you can use it for identification purposes. But if there's no travel document on it, I don't know any. I don't know if you're talking about the social security number. I've heard of that being on social security number, but employment authorization, not so much, because that's the whole reason for an employment authorization is to work. So the work only sounds strange to me. But what they will have on it is that it's not for travel, it's just a work permit. There's no travel document on it. So I don't know if that's what you're referring to. All right, that's going to be it for me. Thanks so much, everyone, for your time. It's good to be back to be able to connect with you all. And as usual, I'm going to work to get back on schedule to be able to come on the live Mondays through Fridays at around lunchtime. So look out for me there. And then you can also look out for the videos that I post every day, just giving you tips and information about what's happening in the immigration world and how you can qualify for a work permit and a green card, how that can be possible for you. Thanks so much for the love. I will be back tomorrow. Have a good one. Bye bye.